hear me. I'm going to go through the stuff that I usually go through. So I'm just going to try and give you a solution for claims. So if you get a claim, then you know how to approach it and how best to deal with it. Okay? So we'll do this. All right. So, say the claims that people can bring against you, if you divide them into three, then it gets very simple. Then as soon as you identify what kind of claim it is, then you know how best to deal with it. So the first claim is going to be a civil claim. I call them the three C's. So civil claim, criminal complaint, and a commercial charge. So CC, CC, and CC. So the first one is a civil claim, which is simply, I'd say, whereby you've caused injury to a party, but unwittingly or unintentionally. That's a civil claim. And when that claim is brought against you, the way you defend it is different from a criminal complaint and from a commercial charge. So my experience in this game altogether, I've been doing this for a while now, is that most claims are not civil, they're not criminal, they're commercial. That's what it says on the sheet. It says a charge. So a charge by definition is commercial. So if you try to defend it using a civil process, even a criminal one, you're going to fail because it's a commercial charge. So when you get charged in a magician's court, when you go there and you're trying to defend using the Constitution, for instance, you're going to lose your case because it's a charge, it's a commercial charge. It's nothing to do with the Constitution. So if you owe me money and I charge you, you cannot use the Constitution to defend yourself. You either pay the money or we come to an agreement. That's the only difference. So what I've realized is what our friends are doing with us, the people who take away your rights, what they're doing is they are using commercial charges by disguising it as either a civil or criminal complaint. For instance, traffic infractions are being adjudicated under criminal procedure rules without them being crimes. So you need to know what the claim is before you can answer it. So that comes around status as well. Because if you don't know what your status is in comparison to whoever's bringing the claim, then you won't be in a position to defend your property. So you need to know who you are. And who you are is a man or a woman. So you're a living man or a living woman. And also, your competency has to be brought to the forefront. So whatever venue you're going to deal with the issue, you have to let the venue know that you're competent in what you're talking about and you have first-hand knowledge of the information. Competency is to do with the presumption of, they call it, presumption that everyone's a child or incompetency. So because you're a minor, everyone's a minor. You're a master until you're 7 years old, then you become a minor. And you're a minor all your life, unless you let them know that you have attained the age of majority, which is 21, 18. So when you drop your documents, let them know those facts. First of all, that you're a living man or woman. Second of all, that you're competent, which means you have attained the age of majority. And third of all, that you have first-hand knowledge of the information. See, that's if you do that, then you are one step ahead of whoever's bringing the claim, because they won't be able to prove any of those three. Because the people who bring the claims usually, if it's public servants, they won't have first-hand knowledge of the information, because usually it's a CPS who brings claims, but the CPS has about maybe fourth-hand knowledge. It's not even first-hand, it's not second-hand. Because they get the information from the police, who get it from somebody else. So they don't have first-hand knowledge of the information, they cannot start a claim, you see. And on top of that, their name itself is a service. A service cannot be imposed. If somebody says they're giving you a service, it's offer and acceptance. So they have to offer you the service. If you don't accept it, then they're going to force you to have the service. For instance, I can set up a cleaning company, call myself Shore Cleaning Services, but I cannot come to you and insist that every Saturday I'm going to come to your house and clean your house whether you like it or not. It doesn't work like that. I can offer you a service and that's about it. So these people who offer services, remember that's what they do. They're offering something, a service. You can either accept it or refuse it. But because it's commerce as well, a service is commerce. So all these people who pretend, who purport to be public servants, they're offering a public service. They never do though. That's the question, what public service are they offering you? Nothing. Okay? So, the point is understanding who you are in relation to a corporation, because all these people are, they represent a corporation, but you have a higher status. Okay? So, I'll go into the identity again. So before, like I said, last time we had a talk, you have to understand that it's an act to start with. What is an act? It's just like it's a play, and it's got three acts. One play with 3 acts. So the first act is the status. So you have to identify who you are and establish your status. Number 2 is adjudication, and number 3 is the judgment. So number 1 is critical. What tends to happen is people who bring claims against you, they skip the first stage and just move to the adjudication.
I'm sorry, I missed this, the second and third. You said first is status, second is...
Yes. The second will be the adjudication now.
Adjudication.
So that will be Act 2. This is the main part of the play. So Act 1 is a setup, like in a normal play.
Right.
Act 1 is just setting up to start.
Right.
And then Act 2 is the main part of the play.
Main part of the play.
Then the Act 3 is the judgment.
Right.
Yeah.
Thank you.
So they're going to skip number 1. Why? Because that's where the game is. That's where the joint is created. And that's where you want to stand. You want to establish your status before. So the wording would be, I am a man before the court. So you are a man, and then before the court. So you're a man before the court. If that makes sense. That you are more important, you have a higher status than the court. So I am a man before the court. So establish your status as a living man. Now, magician's court and county court, they can only deal with corporations, right? So you don't need to be there. So once you establish your status as a living man, they have no jurisdiction over you. And that's that. They might argue and they might have subject matter jurisdiction, which means that venue there can discuss the subject matter, but they don't have personal jurisdiction over you. So you're gonna argue on what they call impersonal jurisdiction. They have no personal jurisdiction over you. The only way they can gain jurisdiction over you is by your consent or by implied consent. So they're going to say something, you're going to say the wrong thing in the book. You say join them, and you say something without knowing. So usually how it's called join the game. As soon as you enter this venue, they're going to ask you the 3 questions. What's your name, date of birth, and address? First of all, you have no name. Nobody has a name. That's an invention. You are known as, or you go by, because you didn't have a name when you're born. Some people get named months down the road. But when you're born, you don't have a name. These things are on you. When you're born, you're completely new, fresh, clean. The name doesn't belong to you. It's just a means to be identified with somebody else. So you don't have a name. But that's what creates a joinder. So what's your name, date of birth, and address? So if you don't give these 3, there is no joinder. And they tend to get stuck. And they don't know what to do with you. Okay? So what's your name? I'm known as, or I go by. Or I use the name, and then you tell them what it is. You don't have a surname. That's what you want to use completely. The surname that's where the entire game is. The surname is the one that creates the money, the surety. The surname belongs to the Vatican, by the way, entirely. So if you accept to use a surname, it means that you accept jurisdiction of the Vatican over you.
Is that for registration?
Registration, yeah. That's the process anyway. So it's to do with the 2 laws. You have law of the land and law of the seas. Law of the land is each land is going on law. So the law of the land in England is going to be different from the law of the land in China. However, the law of the sea is the same. It's one sea. So when you were born, because they use the law of the seas, That's what they use. When you were born, your ship came into the dock and it birthed, and your mom informed the dock worker or the doctor that the ship had come in with a manifest, and you were the goods, and then you registered that way. So that's the point of registration, is to register, is to REGO, REG is to do with, yeah. And when you do birth certificates, is to do with the creation of a trust. So what your parent, your mom has done is taken you, given it to the government, and they've given you a receipt. They've given her a receipt, which is a birth certificate. So now they have a legal controlling interest on you, which is the property. Your parents have an equitable interest, which is just to enjoy being with you. But if they use you, the people who have the legal interest then come and take you, because they're the controlling interest of the trust. They're the trustees, so they run it. That's how they can play this game and get the children away. Because as soon as the child is registered, they belong to whoever has the legal title. Yeah. So with the birth certificate, that's where it is. You've been birthed, your property. And by the way, because these people you're dealing with are corporations, they can only act upon corporations. That's why you have to incorporate for them to deal with you that way. Right. So the thing is, as soon as the claim is brought against you, kill it at the top, at the beginning. Don't let it sit too long. Now the trick is this, because everything is commerce, there's a 72-hour window where you have to rescind any contracts. So what they send you is called a proposed liability statement. You see, these are the bills and all these charges, and it's proposed. They're not real. They're purported. It depends on how you act. They're proposing for you to join their proceedings so they can get paid. So these people, they have no skills or talent or anything. What they do have is a building, an empty building with some chairs, and what they do is write letters out and invite people in. But as soon as you come in, they get paid, because now they're going to create bonds. There's appearance bond, for instance. If you appear in that venue, they're going to create a bond. Performance bonds as well, accommodation bonds. There's a whole stream of bonds that they create based on that. Yeah. So each case number has got all these numbers. Those are bond numbers. So every time you get a form, it's always going to have a number, and you can always trace it back. So those are what they call the numbers used in operations. Those are the bond numbers, because everything is in operations, you see. So everything is common. Don't be duped to believe that there is there's civil law, and there's common law, and there's statutory law. None of this exists. This is the smoke and mirrors, you see. While they're telling you that the statutes apply, they don't do the statute themselves. So who does it apply to? Because they don't follow the statutes, you see. Because it's nothing to do with statutes, everything is commerce. So when you go to court and you lose your cases, because I've tried a few. I mean, I've sued the chief conman because I had him in the high court because he stole my property. And they realized, because my case started 2013. What happened to me is police came to my house, they stole my stuff, they stole computers, plays, flash drives, a whole bunch of things, and I never seen this stuff again. So I tried to sue them, I took it to the high court. And that's when I realized that these people have no honor, because I thought this thing was real, that the courts work, the justice system is there in place. But I went through it and realized it's all a con. What they have there is gatekeepers, what are called district judges. These people are not judges. These are solicitors who have been in the fraternity long enough to be given a raise or promotion. Okay, but there's nothing there. So what they do have is district judges who act as gatekeepers, so that when you make a claim to the high court, they stop it and take it back to the county court. That's all they do there. But what they're trying to do is prevent our cases being seen by high court judges. That's all. Because high court judges, apparently, they have some honor. I haven't dealt with them directly myself. They don't have. Well, there you go. Okay? So people who have, high court judges have no honor as well. Okay? But the point is this, they won't have any honor. Why? Because this country, I think they say there's 60 million people. I don't know how many there are. But there's only 12 independent judges. How is that possible? 12. And those are the judges of the Supreme Court. How can 12 judges manage the whole country? They're all supposed to be independent. Now, all these other ones, apart from the 12 judges in the whole country, they are members of the Bar Guild, which means that every hearing they've ever held is null and void for reason of conflict of interest. Why? Because the judge works for the same interest as the prosecutor, as a legal advisor in court, and as your defense solicitor as well. So now you have 4 people working for the same interest, and you're standing there by yourself until you're going to win against them. So it's a game of allegiances and fraternities, but you're never ever going to get any remedy in those fake courts unless you have the oath, a very certified oath of the judge or the man acting as judge on your bundle when you file it. Otherwise, it's not going to work because they're acting outside their oath, right? Their oath is to be fair and to treat everyone without bias. They cannot do that because all the cases they hear in the magician's court and in the county court, those cases are administrative. You see, they cannot use a judicial oath when they're doing administrative work. That's why you never see the oath, no matter how much you ask for it, because they're doing administration, which is in breach of their oath. Simple. So when they're enforcing this act, what they're doing is administration, it's not judicial. So when you ask them for their oath, they go crazy. You see.
What have you actually done? Have you got a copy of their oath, or you just say you accept their oath? Or you expect them to act accordingly?
Right. They're not going to act accordingly, so we're going to deal. So what we say is this. They're asking you to go to their venue, to be a party to their proceedings. So what you're saying, fine, I conditionally accept. I'm going to come to your venue to be part of the proceedings upon proof that the judge or the man who's going to be acting as a judge can give me a certified copy of the oath. That's it, for my own record. Exactly. Otherwise, I don't recognize you as a judge. Exactly, that's it. So you give him a month before the hearing. See, I'm going to come. I want to see this stuff before then. So give him 2 weeks. So you have 2 weeks. They don't respond. You another 2 weeks. Give them another 1 week. And if they don't, then the day of the hearing, you don't participate. Because now the man is not a judge. You need to see a judge. That's it. Okay? Because I can say I'm a judge. All right? I can say I'm a judge. If you believe me, that's anyone can say that anything. You have to prove your claim. You cannot claim to be a judge and you have no oath. If I'm going to claim to be a judge, I better have an oath. If I'm going to claim to be a policeman, I better have an oath as well. I cannot be a judge, I cannot be a police until I go through the process where I am appointed or elected or whatever the process is, and I'm sworn in. And then I can be a judge. Okay, so these people are not judges. There's one instance where the judge was honorable, just once. Yeah, because we went to the court and we asked for his oath, and he was, I haven't seen it for many years, and okay, he's here somewhere, and he started one of those, the girls around the court. Well, make sure he gets a copy when he go out. Yeah, and we got a copy. Once. Yeah, he was honorable. Was it Hollow Hill, or I can't remember his name, but he was a high court judge in family court, and we asked him for the oath, and he said he wasn't fussed. So I haven't seen that for many years, but it's here somewhere. And he started with the girls to make a copy for the guy when he left. Okay? These other ones, when you ask them, they just go crazy. Oh, I'm not going to give you that. Who said it? I say, oh, hang on a second, are you a public servant or not? Right. He doesn't need the oath in an administrative proceeding, so he's being truthful. Except that you don't know. You see. So when he says I don't need an oath, it actually means he doesn't need an oath to do administrative work. That's what he's doing.
I still need your consent.
Yes, yes. Now the consent is gained by application. What's your name? What's your date of birth? What's your address? And that's the first thing they ask you when you go in. And when you say it, the case is finished. You've lost the case. Yes, that gives them jurisdiction. That means you recognize, and you're going to contract with them. That means that you accept presumption of agency. You work for them, and that means that you're a member of the Bar Guild, and you're guilty. You see, that's it. So he doesn't.
Establish anything before.
You say a word.
Before you
Yeah,
say anything.
yeah. That's the whole point.
If they don't provide you any information
You don't proceed.
You don't go.
You don't proceed. Because the point is you have to participate effectively. So your point is this, I'm not refusing to participate, however I don't have enough information to carry on, so I'm going to stop right here. So until you give me this information, I cannot participate. Yeah, so no one should participate by using tricks, right? You need to participate where a judge actually is acting under their oath. It's going to be fair. Then you can participate. But if you do it in administrative proceedings, the administrative proceedings, right, the judgment has been made before you go into court. You see, because they've divvied out the money already. As soon as you're going to come in, they've handed out the bonds, whoever's been paid, everyone's been paid, the decision has been made, you're coming in and the judge is sleeping. You see, because he's not hearing the case, he's just waiting for, come on guys, finish the act, you see. But that's the whole point. If you don't want to be deceived by anyone, make sure that you make people prove their claims. So if I come to you and say I'm a doctor, make sure that you get some evidence that I'm a doctor. If I say I'm a judge, make sure that there's some evidence that I'm a judge. Otherwise, the way things are now, people are just grabbing. Because like you said, things are changing very fast. In a few years time, they won't be able to do what they're doing because everyone's waiting up. So, that's the point. You see, know who you are, stand your ground, do not be bullied, understand one thing, you're the man, and who's the man and who's the servant. Now, if someone is serving you, how the hell can they tell you how they're going to serve you? You have to tell them, this is how I need service. If you're working for me, this is what you're going to do. You're not going to tell me how you're going to do it, I'm going to tell you how you're going to do it. So when it comes to public servants, you have to tell them how you want them to work for you, not the other way around. Because I'd say they flip reality upside down, right? If you imagine it's a circle with a line in the middle, the top part is white, the bottom part is black. It used to be, the human condition is unconditional love. That's the human condition. However, we have two emotions, fear and love, right? Love is called amor, and then they flip it round, and they call it Roma. And that's where it came from. Okay? Now, everything is upside down in Rome. Okay? You're presumed guilty, and then you have to prove yourself innocent. When in reality, you're innocent and proven guilty. So you need to know what's going on and how things are being flipped around you. You see, so when somebody comes and says, oh, you killed John yesterday, you don't have to go crazy and trying to disprove it and running around hours in there calling people. No, ask them to prove it. That's what you have to do. Whoever brings the claim has the burden of proof. So I don't have to say anything. If you bring a claim against me, you prove it. Right? So that's our condition. We need to know who we are in comparison to our servants. You see, because our servants are beating us up. You think, how is that possible? That the servants are running the house. You see, no. The people have the power. So the people have to take back the house and tell the servants how you want to be served. We don't want our stuff stolen. We don't want to be bullied. We don't want to be cheated in these fake courtrooms. We want a system that works. Okay? We know the system is dead. However, the men and women who work in there right now are the corrupt ones. We need to get rid of those people and put people with principles in there who can reverse this thing and let it work the way it was meant to be. Apart from that, there is no backing down. We are not backing down. Because I've done this for a few years now, and I haven't seen a response from the other side. All they do is tricks. They have no answers, you see. So we know that everything we do is wasting fire. Okay? And we can kill it at every level, you see. So, it's a matter of claims. Make sure anyone who brings a claim against you, they can prove it. If they cannot prove it, then notice commas. You need to start enforcing your fee schedule. You need to start valuing your time. How much is your time worth? Is it worth your time for people to drive into court for sometimes for a whole year, in and out, and they're getting paid, and you're getting no money, you're going to claim expenses because you don't know how. So every time you go to the venue, make sure you get your expenses. For the time you've wasted preparing the paperwork, the stress as well, you see, for all these fake cases, because the cases are not real, the charges are false. Because we're talking about the four elements that create a true charge the other day, last week or sometime. If the four elements are lacking, it's a false charge. So all these charges are false anyway, you see. Because, account, the four elements: account, obligation, right of claim, and jurisdiction, those four. The account is the presumed account that's created by your national insurance numbers and your birth certificate numbers, or socialization numbers, those ones. But it's been done without full disclosure, or without your consent. So it's not a true account. So you don't close it at that point, you see. But we do know an account exists, you see. In any case, everything that we're bringing against you now is going to be a charge. You see, it's not going to be anything else. So as far as the charge is concerned, deal with it in the commercial way. Okay? As long as you deal with the charges in the commercial way, you'll be fine. And how do you do that? There's only 4 responses in the world of commerce. Acceptance. That's why you accept things for value. You see, when they send you the bill, you have to discharge it properly. So there's videos and information on how to do that. It's straightforward. Accept it for value. It means you're accepting it, you're not disputing it. Second is conditional acceptance, which is you're accepting it, but you need some proof from them. Okay? So if you do those 2, you're going to remain in honor. And you'll win your case. If you do the other 2, which is to ignore or argue, you're going to lose the case because it's commercial dishonor, because everything is commerce. You see? So what we do is accept stuff, accept it for value, do the signature, and then do the authority. So you sign up for the authority, which is going to give them the way to go and cash it. Okay? Or conditionally accept it, which means, okay, fine, right now I'm not going to refuse it. I'm conditionally accept it upon proof of claim of how the liability was created, for instance. And then give them 2 weeks. So if they're unable to prove how the liability was created within 2 weeks, it means that there is no valid claim. And after 2 weeks, then you write to them and say, listen, because you haven't given me the information, it means there is no valid claim. So you create your own agreements. Remember, you have to be competent yourself. So everything, the court is the paperwork, it's not the building. And what is the bond? So it's the contract. And because it's legal, it's a letter that matters. It's how you draft your contract. So it's pretty straightforward. I conditionally accept to pay you the £1,000 that you claim, I owe you, upon proof of claim of how the liability was created. 1 sentence, please give me this information within 7 days. 2 sentences. The third one, if you don't, give me the information within the 7 days, it will mean that the claim is invalid. That's it. That's it. Done. So you can extend that or shrink it down, but that's your entire game. Is you're making a claim, prove it. If you're going to prove it within a certain time, it means you've abandoned your claim. That's it. So that's how we've been dealing with these people for the last 8 years. And the commercial stuff works all the time. So the only people I'd say are a pain in the ass, and they don't do anything. We just keep writing to you, but they don't do anything. It's the council. It's council tax business. You see. But everybody else, they're pretty keen. They're pretty good with the commercial stuff. They're respected. But that's the only thing that works. Okay. Any questions so far?
Yeah, I've got a question. Very important to me. I like what you said. I've discovered some of this myself. Many years ago, I got a parking ticket on a vehicle that I had transferred the ownership. And I actually had 3 tickets, 2 for the congestion charge and 1 a parking ticket. I successfully got the 2 congestion charges cancelled by saying I've transferred ownership of the vehicle. The other one with Bromley Council, they decided not to. Now, I've followed a lot of this stuff for a lot of time, and I wrote them, I submitted my fee schedule, I've written all the things saying, you know, I'll do this if you follow me through. And I'll just briefly say the case. It went for about 2 years, right? I know that I transferred the vehicle, so I've actually been to the DVLA office myself and done the paperwork, so I know it's been transferred. But it never got done at the DVLA. I managed to get the DVLA to retrospectively change the transfer though. But I didn't tell Bromley Council this for a while, because I just wanted to see how far it would go. And one of the things you said about accepting, I sent the fee schedule to Bromley Council, and they sent everything back to me, including my envelope, saying they had taken copies but they weren't accepting. So, yeah, that's one of the things you say. So clearly, some people understand the process, but I do wonder how many of the officious little gits in the council, for want of a better expression, understand what you're doing. Because as you say, they just write for you ad infinitum.
Okay. What you have to understand is this. The police and the council, they have no idea what this stuff is. That's the trouble, you see. Because they don't know the law. they don't train it. They train you filing, presumably in the council, they train people how to file documents and run around the office, faxing things and doing things like that. But they don't teach them about the law,
Yeah.
you see. So this, probably the seniors will know, but not the minions.
But I always wrote to the chief executive.
Yeah, that's the point. Once you do the notice of principle, he's supposed to tell everyone else on the chain of command, all the way down. So that's all you have to do.
Yeah.
Okay?
I would say in this case it ran, they instructed bailiffs, debt collectors, who were visiting my home. I was fine with it, also my wife was a little bit nervous about it. But in the end, it was just cancelled when I informed them of the DVLA change and done retrospectively. But as I say, I was letting it run as long as I could, because I just wanted to try out some of this stuff. But
That's how we started
working.
anyway. For me, that's how I started. When I first started doing parking tickets, we did it for 8 months for £35. Because the parking tickets were £35. But that's how we learned the process. Because we wrote to the council, they wrote back without the answers, and we were writing back and forth for 6-7 months over £35. But then when you do that, then you realize, oh my God, they have no answers to anything. So now we don't even go that far. We have answers for most of it. It's 2 lines to do with parking tickets, 2 lines to do with council tax.
And do you find that it now works? That if you go through the process that you've defined there, then they will stop?
If you do it the commercial way, they're going to stop it.
Right.
Yeah, because with parking, it depends as well. With driving, you see, because you have you've waived your rights. Put it like that. When
I
you
never signed any of their forms.
Yeah, but your DVLA form, that's where you waive your rights, you see.
Right.
When you take a document that doesn't have any other signature, your agreement is only you. It's a unilateral contract. You're the only signatory. Because you took a piece of paper, you signed it yourself, and sent it to DVLA, and thereby waive your rights, you see. But there's still the difference between business, traveling and driving.
Yeah, but see, I know in this instance I hadn't signed the form properly. Yeah, it was a taxi that I'd used for a campaign. I'm a UKIP member of the council here, and so I was deliberately being obscure with who owned it.
Yeah.
And I never actually signed it. I just scribbled on a bit of paper and handed it in. So it wasn't in my name, but at some point it had been registered to me.
Yeah.
And that's why they're coming up.
I'd say right now what I do for public utilities or public proposals, like statements, is to accept them for value, even the parking tickets, because that's to do with the council. So we were talking about parking tickets, electricity, gas, water bills, all those you can accept for value, you see. So when you get the parking ticket, accept it for value, because you got the parking ticket while you're doing business, if you will, so you can write that off as a business expense. So you can accept it for value, you see, if you're driving. But if you're traveling, then you don't pay any parking tickets. So you just have to decide, was I driving or was I traveling? Which was which? Remember the traveling? Traveling is when you're doing your private business. Driving is when you're conducting commerce. When you're driving, all these rules apply. When you're traveling, they don't. That's the only difference. So when you're traveling, you don't get a parking ticket. When you're driving, you do.
Just to clarify, when you were sitting in the selling to them private,
Now you realize that all the envelopes are private. All of them. Private and confidential. No one's right to private. You see? So you have to decide, because by now we all know about this, your strawman, right? So you have to decide whether you're going to represent the strawman or do you want to be the strawman. That's the difference. But when you sign the documents, I mean now for anyone I'm working with, I always encourage them, please sign AR for the strawman. So the authorized representative for the strawman. So it's John Doe, AR for John Doe, in all caps. There you go. So you detach yourself away from the strawman. It's not me, but I'm the representative for it. You see. Some people cut themselves away completely from the strawman and just leave it. And I'm thinking, I'm going to represent the strawman. It's not me. Exactly. That's the whole point. You're supposed to be solicitor for your strawman. So in a
Strawman's the agent,
You're the agent for your strawman. Because corporations, the government cannot deal with the strawman. The council cannot deal with the strawman. All corporations cannot deal with the strawman. You see. So you're going to be the agent for it. Or the representative for it. So that every time you write a document, you make that clearly known. I, the living man, am the only authorized representative for the strawman. Yeah. But one thing, you don't want to be the strawman. We don't want to represent it. And you certainly don't want to be in a dock. You see, that's a trick as well. When they ask you, oh, go to the venue. Right, the venue is called a vessel in dry dock. That's what it is. It's all the seas. Imagine it's a ship that's come from the sea but somehow managed to land in the middle of the country. But the law of the sea still apply when you go into that building. You see, that's the only thing. So as soon as you walk into the building, you've gone into a foreign vessel in dry dock, okay, without a seaman's pass. So you're in a foreign country without a passport. So they can do whatever they want to do. Once they grab you, they can detain you as a stowaway. That's why the captain, who is a fake judge, can send you down the gully if you misbehave in his ship. And the laws of the country don't apply in that ship. It's a foreign vessel. That's why it's saying he can say whatever he wants to say. He can do what he wants to do. He's his ship. That's why we shake them, and then he walks away. We ask him what his name is, or whether he's indemnified, or whether he's on oath, and he's going to jump up and leave the ship. And then you take over. You say, you're the captain, because the captain is like the ship. Now I'm in charge, because I'm the sovereign now. And I'm discharging this case. That's how you get rid of a judge. A fake judge in a magician's court. Yeah.
Well, they do really write up charges in some cases where they're arrested with payment.
Well, that's the whole point. So what's going to happen to us? Are we just going to allow these people to do these things, or are people going to stand up? And so if you come to arrest me, first of all, police have to act on oath and warrant. Oath, because he's acting on his oath, and warrant, because he's got his warrant from the magician's court, or wherever he's got it from. But they don't even have that. Now they're arresting people without oath and warrant. So that's the whole point. Are we going to allow these things to carry on, or is enough is enough? Do we need to go back to reality and start dealing with people with principles? But the point is, they're arresting people without cause, a proper, reasonable cause, you see. And police are being used as bailiffs as well. So if you have a dispute with somebody, your landlord, for instance, and you owe them money, they send the police to come in with the bailiffs to come and break in and take whatever they need. That's completely wrong. The police only are meant to deal with criminality or crime, not to act as bailiffs. But that's what's going on now. Yeah. So the point is, we have to stand up. The people have to stand up for their rights. So the police stuff, I'll leave it out. I have a little note here. Coming back, there's 5 questions that we have. We call it public service announcement for the police. It's just 5 questions that we ask them, and then, oh, here we are. These ones here. 5 questions, they never answer. Number 1, are you acting under oath? You see, and if that's a very simple thing. If they're not, then they better move it, because it's just as good as you. Number 2, I'm not obliged to speak to you. Obligation is duty. So if he's acting under oath, I'm not obliged to speak to you. Yes or no? You have no obligation to it. If you haven't breached the peace, goodbye. Number 3 is, have you observed you breached the peace? Because the only reason you have the police around is to prevent breaching of the peace. That's it. That's their only job. They have no other job except to prevent the breaching of the peace. That's it. Everything else is all the acts require consent. Okay? And then, if you haven't reached the peace, then am I being detained? If you haven't reached the peace, why are you being detained? So am I being detained if I haven't reached the peace? The answer is no, goodbye. And then the final one is, if they say they're detaining you, a good one is by what law and what authority? That's it. Is it statutory law, common law, commercial law? And authority, where do you get authority from? Yourself or from the magicians? Or from a high court judge? That's it. Who? By what law and by what authority? They have none. It's presumed. You see? That's how we deal with those guys. Okay? So, commercial process, remember that. Acceptance and conditional acceptance. Every proposed liability statement that is sent to you, you have to respond within 72 hours. That's 3 days. So they tell you, we give you 21 days, that's the trick. So you can go beyond the 3 days and the contract becomes live. So you should do it as soon as you receive it, send it back, accept it for value, or conditionally accept it, send it back, remain in honor. And then you can use your evidence that you've remained in honor. If they ever take it to court, then you just produce the paperwork and file it. Okay? Right. Proceedings, like I said before, all proceedings that they're going to bring against you are against property. Okay? So they want your property. That's all they want. Right? So proceedings are in rem. So in your defense, you could always use that. If somebody brings a claim against you, you can ask them that. We've done that with the police. Question is this: are your proceedings in rem or in persona? And they get stuck because they don't know. Are you proceeding against me or against my property? Well, every single police officer is meant to be a legal officer. That's why they can enforce the law, because they know the law. So if you know the law, then enforce it. If you don't know the law, then you're going to enforce it. If you claim to be a brain surgeon, you need to know the brain is. So if you say you're a police, you need to know some legalities.
So you're trying to reduce us to things.
You're trying to?
You're treating us as though we're the red.
Yeah.
If we're doing that, that's why I say it.
Yeah, it's because it's property. You see, you're a thing.
The name is it.
Yeah.
And you say, yeah, that's me.
It's about it, and they call you a thing as well. A thing in property, in a magician's court. You're a thing. Yeah.
For all these papers up there.
Yeah, you're going to get frustrated. But the thing is, once you know the game, you need to get the script. Once you know the script, then life is easy. When you go into these venues, what do they want? Create a joinder. Once the joinder is created, it doesn't matter what is said in there. They don't listen to truth and facts. No truth or fact shall be heard in a court of law. That's it. So you can rant and rave as much as you want. They can't hear you. So the best thing is do your stuff on paper. Paper is the court, and paper is evidence as well. So everything you've written to them, you have a copy. And you can always use that 2 years down the road, 5 years down the road, to get whatever remedy you want. But keep your evidence, you see. That's it. So proceedings are in rem. It's always an offer. You have a choice whether or not you want to accept the offer. When you send your summons, it's an offer. It's an invitation to leave your sovereign state and go into a foreign vessel in dry dock to defend a legal fiction. It's up to you if you're going to do that. You can write to them in those words. Thank you very much for inviting me to come to your foreign vessel in dry dock to defend a legal fiction, but I won't be coming, thank you very much. Unless the judge shows me an oath or whatever questions you want. That's it. Keep it simple as that. And if you, they can rule it out. Another thing is this. A court of no record cannot render final judgment on any matter. That's it. There's a court of no record. The only people who can render final judgment on a matter is a court of record, where the judicial office holder is appointed for life. That's it. So every magician's court decision is not final. You can pull it up any time and get it reheard and retried. Something like that. They have no authority to render final judgment on any matter whatsoever. And people just believe that magicians, that they have some power. They have no power. Okay? Rubbish. Alright? Right, the three, let's say the consents are implied consent, expressed, and willing consent. So the ones you want to give are the expressed and the willing only. So anything in implication, you're not going to accept that. But everything they do is presumptions and implications. So you want to avoid being tied into contracts by implication. And you want to be in control of whatever you need to do with the case. And always remember, your case is your case. Their case is their case. Look at it as a suitcase. Understand? You cannot get into somebody else's suitcase. So whatever case they bring against you, ignore it completely. You focus on your case. What's your issues? And deal around that. And take care of your case. It's like a suitcase. It's a suit as well. Suit. A suit. When you sue someone, it's a suit. That suit is a suitcase. Your case is your case. You carry your case and don't be drawn or dragged into somebody else's case. But that's what they tend to do with us. They'll make false presumptions, and then we start defending those false presumptions. Instead of saying, no, I don't have to do with that, this is me and this is what I'm doing.
We're playing in their jurisdiction. It's in the case, in act, as long as you're in, they take over your case, and they literally do it.
Right. The way I draft my documents is this: it's my court. There's going to be at Troy Court in Leeds Magistrates Court. There you go. So it's my court in the building, but it's my court.
Do you get pushback when you get those findings through?
You'll file it because you file at reception desk, but what they tend to do is to ignore it. So when you go in there and ask them questions with the issues you want to raise, they don't want to talk about it. They want to talk about their own issues. Remember, you want to talk about your own issues as well. So don't get dragged into their issues. But that's the trick. To ignore everything you say, you just carry on with what they're doing. And eventually, they're going to break you down. Send me the police. Send me the police. Eventually they're going to break you down. It's a matter of time. Because whereas you have, I'd say, when they arrest you, you want to go home. You know, you're anxious. You want this thing done quickly. These people, they can put people on shift. You see, I can be there 24 hours. They have how many people? 4 people come to see me. 4 different people do that 24 hours. So they have plenty of manpower to be busy. But you need to be resolute. Once you know who you are, you don't back down. And no matter what they do, you don't back down. That's the trick. Is to wear you down. People just don't want to be hassled. That's the thing. If I can pay 35 pounds to get rid of this ticket and never hear about it again, I'm willing to do that. Everyone's like that. You see, people just don't want hassle. But if you're willing to put up with the hassle, yeah, stand your ground. Once you stand your ground, you realize they have no ground to stand on. That's what they call legal standing. You see, you have no standing to bring this claim. So you can use this word as well. Once you ask the questions, the proofs, okay, and they fail to provide the proofs, then you can write a statement. I don't believe that you have legal standing to bring this claim, because now you have the evidence that you don't. Because you ask them for the simple questions, and that's how you kill these cases. You see, but yeah, it gets easier after a while. Once you know what you're doing is proof of claim. If you cannot prove your claim, you don't put a claim that your claim is invalid, and that's as simple as it gets. And that's with all claims. Because everything legal starts on paper. You see, everything real, like in real law, you have to go and commit an act for the process to begin, and then they'll come after you. In this legal fiction world, it begins with a letter. Someone writes you a letter, and depending on how you respond to it, the case is going to build from there. So make sure you kill it as soon as you receive the letter. That's how you kill it. Okay? Yeah. You can put it in those words exactly, or you can draft it whichever one you want. If they're making some presumptions directly, you can just say, I rebut your presumption of custody, or rebut your presumption of agency. Whether you understand it or not, I don't care. Go and tell your boss. You see? Yeah. I mean, I've told the police that, put me in custody. I say, you cannot put me in custody. And I say, listen, I rebut your presumption of custody. And I have to explain to the guy, he didn't know what I'm talking about. This is the custody sergeant is supposed to know the law. You see? And I'm trying to explain to him that you know what custody means, the legal definition of it. You know you cannot put me a little man in custody. You don't put property in custody. But because I'm moving in rank, they're taking me to be property. So they can put me in custody. You cannot do that. So I'm going to rebut your presumption of custody and take it from that.
I think it might be a good idea to start reactive action against
Yeah, with the police, the best thing to do is this. Is to ask them about what authority are they doing what they're doing. They don't have any authority to start with them. It's best to do the fee schedule, or to give them your terms and conditions for doing business with you. Okay? Tell them, listen, I'm a lawful man, I abide by the law. Okay? I'm not going to cause any harm or injury to my fellow man. However, these are my fees for anyone who wants to do business with me. And then you put your fees down. So if you stop me, if you arrest me unlawfully, it's this amount. If you handcuff me, it's this amount. If you stop me for anything except a common law offense or common law cause, it's this amount. And that's what it is.
And then perhaps there are further actions against you.
I'm sorry?
They do continue to harass you against their aggravated.
Yeah, but now you have a fee schedule. Because remember, it's commons. Now you give them notice of your fees. If they come and engage with you, they accept those fees. And now it's not a civil matter anymore, it's a commercial thing. It's paying my money, according to our agreement. You see, we don't have litigation.
It's you making the offer this time.
Yeah.
It's you saying, okay, you've made me another, here's my
Exactly, it's offer and counter offer. Except they make us offers and then we start defending and fighting it. We're supposed to give our counter offer. In commercial world, you get 4 headings, right? How to do it commercially? 4 headings only. That's how simple it is. Number 1, conditional acceptance. So I conditionally accept anything they say. Number 2 is called a statement of facts. So you're going to put down the facts. I'm a living man, I'm competent, and all the stuff that you're going to put too. The third heading is statement, is memorandum of law, you see. I use maxims. We don't use statutes, because maxims are the real law. So you're going to put about 10 maxims or 5, depending on how many you're going to put, and depending on the relevance of the case. And then finally, the fourth heading is notice of fault and counteroffer. That's it. That's the 4 headings for a commercial response. If you do it that way, always wins. Because now I'm not refusing anything. I've conditionally accepted your offer. Okay? I've told you statement of facts, statement of undisputed facts. Okay, I'm a living man, I've always done this undisputed memorandum of law that you're operating under, which is maxims of law. All men are created equal, all men are equal under the law and all this stuff. And then finally, notice of fault. So tell them this proposed liability statement you sent to me, I think it's in error, and then give them a counteroffer. So the counteroffer would be, please give me the information I asked for within so many days. If you don't, the counteroffer is this, you're going to cease and desist with any further communication. Okay? Or you're going to accept the fee schedule. If you communicate with me, you're going to pay me £25 per letter for administration. You see? And now when you send them the bills, you send them your bills. And you can set yourself off. But remember, it's promise. So just conduct your business properly. That's it. Yep. Okay. Frank Mail. Right. Service of process. When somebody serves legal process on you, right, there's about 7 ways that you can do it, but the ones that are accepted are 2, either by hand or by a recognized process server. If it's not done that way, the process is defective. Okay? So always watch how you accept service. Do not accept service by electronic means.
Right. On the phone now, is that the same as the prepaid? The prepaid isn't service, is it?
No, frank mail is not prepaid.
No, but you get the prepaid, but on some envelopes you actually get prepaid.
Well, they're paperwork.
Sorry?
Well, they're envelopes.
They're envelopes, yeah, they come prepaid.
Yeah, yeah.
So that's not
That's not proper
service either.
service.
No, thank you.
That's not proper service. So if the envelope is prepaid, or it's got those red marks on it, frank mail, that's not proper service. That's defective service. Okay?
So what you need is a stamp,
A stamp
right?
on the envelope,
Right?
that's completed post office,
Yeah.
and it's been cancelled.
Right, so that's proper service.
Yeah.
Thank you, thank you.
And it's the recognized process server. So in the court building, there are process servers as well. So you go in there and hassle them and pay them to serve something. There's other means as well. You can receive phone calls, you can receive emails, but don't take those because emails are public, you see. And also emails are not, no one accepts liability to send an email. But if I do send a letter, right, I'm going to write it, and I'm going to sign it, and I'm going to put it in my thumbprint, means I accept liability for that document. But email, you can send anyone an email. So we don't do email. Okay? So watch how you accept service of process. And always raise that issue. If the process has not been served properly, you always raise it. Because the procedural rules say this. If somebody serves you documents outside the rules, but then you accept it, and start dealing with the issues, then it's deemed that process has been served properly. So if they set a dog with a thing on it, and you take it, start dealing with those issues, then service has been effective. So watch out how you accept service. Because court can only gain jurisdiction through effective service of process. That's it. If you haven't been served properly, you don't go to the court. But if you do go, say your service was defective, which nullifies proceedings. Alright? That's a trick. So they're going to send you front mail and see what you're going to do. And because you don't know what they're doing, they're going to send front mail to a legal fiction in all capitals with a Mr. in front of it. And because you don't know what that is, you're going to open it and you're going to start dealing with the issues in it. And now you join it. If you're a Mr., then you're a Mr. So your mother never called you Mr. Where did this Mr. come from? It's a title that's a dead bonded slave. That's what a Mr. is. It's a dead bonded slave. Or a civil term, which is simply civilly dead, or non pure, name of war. Because we're under occupation, military occupation. So when you use this name of war, it means you're enemy combatant. That's why they treat you the way they treat you. Yeah, the occupied, the occupant. It's always military term that they use. Defense, attack, command and orders. It's all military, general, all these people. Everything is military.
Private is a military term.
Yeah, private and military. Infantry, infants, infantry. You see, the infantry used to be the children, soldiers of Rome. They used to like children to go fight. That's the infantry. You see, but they still carry on today. They go to the infantry. Sorry. By hand or by a recognized process server. So a recognized process server is one of the people who work in the courts, and they do that, or post office. But you have to be registered. Yeah, registered mail. That's a recognized process server. The best one is post office, UPU, because the post office was the first courts of the land. They still are. So the post office is the first court. So you use the post office and puts it under common law jurisdiction. Yeah. So let the post office serve them, and let the government serve in the process. So whereas you can prove service, they can never prove it. If they frank something, you just put it through the mail. How the hell do they know you're going to receive it? But with your one, okay, you've registered it, recorded it, and they've signed it at the other end. And then if you go online, you can pull it out anyway. It's going to show you when it was delivered. That's your proof of service. You see, yeah.
It's deemed served, and it's posted service. Deemed served.
Well, in the legal fiction world, anything is possible. Okay? It's to do with deemed, seems, appears, purported. That's it. Everything is presumption. So I deem.
And then uttered.
Or so. You read about everything these people do, because look, their very existence is fraud. They shouldn't exist at all. There shouldn't be a group of people whose purpose is to give another group of people a hard time, like through lies and deception. What's their purpose? The only function of a court is to protect the individual rights of the people. That's it. The court has got another function. But now the courts are working for the corporations. You see, they've bought the judges or whatever they've done, either bought them or appointed their own people. The courts are working for the corporations. They're taking houses of people and giving it to the corporations, the banks. You see, but the courts, their only function, the reason they are created, the inherent common law jurisdiction of the court is just that: protect the individual rights of the people. That's it. So you need to let the judge, or the man acting pretend to be a judge, tell him the only function of a court is to protect your rights against the corporation. But they've reversed it now. They're taking your house and giving it to the corporation. And the corporation is selling it to somebody else for a few years, taking it off them, and selling it to the end. Yeah. That's it. Yeah. So yeah. For now, I've got any questions and I can expand any other issues. But the point is that it's a commercial process that you need to focus on. Yeah. Any?
Is there a good place to research commercial processes?
Yeah, there is. I'm trying to think with science. Yeah, there are, but because it's so wide. My stuff is things I put together over the years. But I have notes. I just have to find the websites, but they are.
Right.
I suppose Google is pretty good these days. If you just Google commercial process for dealing with things, and that should bring something
Yeah,
up.
thank you. That's the sort of help I wanted. Thank you.
But I have my notes. I'll probably get to the website where I get my information from. But if you Google somebody like Frank England III, he's pretty good. They killed him. He's dead now. But when he was doing his stuff, his commercial stuff is right on point. He's going to explain everything. He's going to explain from the beginning.
Right, so
Yeah.
it's Frank England the Third.
Yeah,
Thank you.
Frank England III. I think it's Freedom Pages, Freedom something. I don't think now. It's Freedom something,
Right.
and it's Frank England III.
Okay.
Yeah.
That's lovely.
It's very, very good stuff on the commercial process. Yeah. So everything is commerce.
Just wanted to say, I've noticed Google's recently definitely heavily censored.
Yeah.
Start page is a search engine which doesn't store any share any information about your searches, but it uses the same, it accesses the same information as Google, but without any of the censorship. So start
Yeah.
page rather than Google might be
Start page.
startpage.com.
I mean, Google's a double-edged sword.
Start
It's a
page.
double-edged sword. It's pretty good, but it's pretty.
Dutch company. Well,
pretty
just a
bad.
few weeks ago, I was looking at CEO, top 20 CEO charity wages, and not one came up in the search. It was all this charity, that charity, this person's been appointed CEO of it, but nothing to do with the wages of the CEOs of any of the. And then I went on
You
start
need to go
page.
to you need to go to Charities Commission. And then from there.
Yeah, that's if you know that. But if you just type that in as a question, it just blew my mind that Google didn't show up any pages that highlighted it. But when I went on the start page, it was like,
Yeah, funny, isn't it?
you know, like the search engine used to be.
So who owns Google now?
And then,
Who owns Google?
CIA.
well, yeah.
Yeah, I think so. I think it's DuckDuckGo as well.
Well, they even recently admitted that they're, because of this whole fake news meme that's going round, they've agreed to do their bit for the fake news cause.
There's a video up there of someone searching for things to do with the American presidential election, and it was the predictive searching. So if you typed it into Google, it gave you nice sanitized stuff. So like issues of Clinton, Hillary Clinton, and things like that. Whereas if you were doing it on a different search engine, Yahoo, it brought up the stories that they clearly were manipulating the searches.
Yeah, I mean the searches are so
They've
different
sped it
now.
up recently.
It's very crazy because the thing is, if from my computer, if I Google anything, if I Google England from my one, and you do the same, it's going to give you different information.
That's right, yeah. Because that's IP to IP. That would be general.
Who said that they can choose that? Let me choose what I want. Don't choose the stuff for me.
Yeah, but it's all your previous search history. So if you go around your friend's house, it just searches things like celebrities and football and all that, and you type in the same question, he'll get different replies based on his previous search. Do you know what I mean?
Yeah, it's crazy. It's crazy. So yeah, Google's a double-edged sword. It's there for information, but it can pretty deceive you as well. So you got to be careful how you use it. Yeah, because they are taking over where television used to be. I mean, television is a terrible tool. It just brainwashed so many people, and people actually believe the stuff on television. And I can't convince them that that's how it's not real. It's program. It's not television programming. That's what it is. It's programming you to think a certain way. That's the whole point. Everything on television is scripted. Even the news is scripted. There's not a single word that gets on television without being scripted. People believe that stuff. You think, oh man, we can't help everyone. Be as blunt as you want. Right. Should I just run through the thing quickly and then I'll finish? The presumptions again. They have 12 main ones, so as long as you regard those 12 presumptions, you'll be okay. So the first one is presumption of public record, that the fake courts are recorded for perpetual perpetuity or for memory. They're not courts of record. Okay, a court of no record is not a real court. That's a meeting of members of the Bar Guild. That's what they all are. You see, that's what it is. They're not courtrooms. Even if you see, when you look at the paperwork, it's going to say that. It's going to say event scheduled at the venue. You see, it's not going to say a trial at this court. Look at the magician paperwork. Event scheduled at September the 1st at the venue. Venue is there to do what? Create revenue. That's what it is. Revenue. That's all they're doing is collecting money. So public record, presumption of public record, instead of being rebutted. Number two, presumption of public service. But these people are public servants, so they're providing a public service. They're not public servants, they're not providing a public service. It's a private meeting of the bar members club. Okay, it's not public, it's a private meeting. That's it. That's why you're the only stranger. All the other characters are aligned with the Bar Guild. They're all members of the Bar Guild. So you can even stop a case on that only. You can stop a case for reason of conflict of interest. So I'm not going to proceed. Why? Because all you people act with the same interest, and stop the case at that point. Third one is presumption of public oath, that they're acting on oath. They're not. That's why the judge can say that. Because it's acting on his administrative office, it's not judicial, so he's not going to act on the oath, he's not on the oath. Fourth one is immunity, presumption of immunity, that these people have immunity, they can do whatever they want to do and they cannot be sued. They don't have immunity anymore. That was removed by Montproprio. Francis Montproprio removed that completely. And a few other treaties, Vienna treaties, have removed. There's no immunity for corruption in public office, put it like that, no more. So they individually accountable for their actions. Number 5 is presumption of summons, that they have authority to summon you, a living man, that a dead corporation has authority to summon a living man or woman. They don't. It's an invitation, you can turn it down, or go if you want. It just depends how you deal with it. Presumption of custody is number 6, that they can put a living man into custody. You can only put a thing into custody, right? So rebut the presumption. Presumption of court of guardians, right? This is the cleric of the court, because it's got, you live in a district, it's a constituency, and in there is a ward. We are ward of the court, and the local cleric, he's got control over his section or his parish. That's the clerk. That's the cleric, the clerk. Yeah, the clerk of the court is the cleric of that area. So that's the guardian. He's got guardianship over that area. So when you go into his court, he's got guardianship over you. That's why he can do whatever he does. So you need to rebut that. Let them know you're not a ward. Okay? And trustee, presumption that you're a trustee, because what it is, they're running a trust account. A trust is a triangle. You have a grantor on top, you have a trustee and a beneficiary, right? They are the trustees, you're supposed to be the beneficiary. But whoever's bringing the claim is claiming to be the beneficiary, and the guy pretending to be a judge is claiming to be the executor of the estate in your name. And then you're the trustee who's acted inappropriately, and you're going to be punished. So you're going to be fined or in prison or whatever, depending. So you need to rebut the presumption of trustee. Let them know that you're the executor of your name. That's it. Rebut the presumption that you're a trustee. Next one is presumption of government. And these people work for the government. They don't work for the government. Okay, they work for themselves on private bonds. They're conducting business. The government has allowed them or sold those courts off a long time ago. Now they're not part of the government anymore. Okay? So don't believe that they work for the government. Zero. They don't. Number 10 is presumption of agency. Yep, you know what that is by now. That's the corporation, right? Presumption of agency, that you work for the corporation because you have corporation documents, you see. Your driver's license, for instance, is a corporation document. So when you produce that, the presumption of agency is established. Okay? And then presumption of incompetence. When you go to court and somebody's holding your hand, your solicitor, it shows you're incompetent because you don't know what the law is. That's why you have to bring somebody else to speak on your behalf. That's a demonstration of incompetency. So you have to demonstrate competence by filing paperwork before you go into court, 21 days ideally, 14 days good, or 7 days as an emergency. That shows your competency, and you're drafting your documents as well. The way you draft them shows you're competent. So let them know you're not incompetent. So they cannot presume that you're incompetent. And the final one is a presumption of guilt. That anyone who goes into those venues is guilty. Yeah. So the 12 presumptions that if you rebut those, they can't move.
Guilt means debt, doesn't it?
Yeah, gold. It's gold. Or guilt. That's the bar guilt there. It's guilt.
Guilt is it's also G-I-L-T.
Yeah, it's G-I-L-T, G-I-D at the end, T at the end. G-E-L-D, the same thing as well. G-E-L-D. Yeah, so it's guild, guilder. So that's to do with money. But the guild is the bar society, the law society. That's the guild. And you can only be guilty if you're a member of the guild. So I'm never ever going to be guilty. I'm either accountable or committed a crime, or not accountable, or innocent. That's it. But guilty, not guilty, no. So when they invite you to plead, remember these words, plead. Never ever ever plead in these venues. Because it doesn't matter what you plead. As soon as you plead, you accept the jurisdiction of the court. You see, and that's it. Join them. Done. So you don't plead. If you have to To enter, you enter the mirror, which means they have to stay proceedings until certain issues are settled. So you enter the mirror, but you never ever plead. Never. You see. So that's it for presumptions. And yeah, I think that's good for now. If you have any more questions, I'll take some more. And we'll see what else to do.
That's very good.
I was going to ask about when you're bringing my claim.
Yeah, go on. Yeah, go on. Right.
Using the same points of the puzzle when you're defending yourself against their attacks.
Right. The thing you want to realize is two worlds. There's a real world and the fake world. The fake world is the magician and the counterfeit. Okay? Completely. When you bring your claims, you want to take it to equity. Of course, of equity, chancellor. Yeah, so you want the king of the Queen's bench. That's what you want. You see, because those are superior courts. Magicians are the inferior courts. Yeah. The man can only be heard in equity.
Oh, I've done that, sorry.
The man cannot be heard in a magician's court because you're living. Those venues deal with dead corporations, so they cannot hear you. For you to be heard, you have to be heard in chancery by high court judge. Now the trouble is this: every time you put a claim in the high court, the gatekeepers or the district judges, they're going to grab those and try and take it down to the county court. That's what they're doing now. They don't want any high court judges or equity judges to see the cases, because equity is to do with fairness, not so much legality. Whereas magicians and counties do with legality, more procedure than the law. You want more law than procedure. But it's a different approach when you put your claim in equity. You have to invoke the inherent common law jurisdiction of the courts. And all courts are courts of equity. That's how they began. Those courts were created to enable the community to be fair. So that's how they started, as courts of equity. And then eventually they changed them into this legal business. They became statutory courts. Now it's a business. And Court of Equity in Leeds, for instance, meets, I think, once every 3 months. Imagine that. Once. There's this one judge who comes over from London, and you have to wait for him and try and get him to see the paperwork. There's only one equity judge.
Be a chancellor.
You have to be a chancellor? To do what?
Chancery.
You have to be a chancellor. I don't know whether you have to be a chancellor. I don't know if you have to be a chancellor.
Delegated by the chancellor.
Everyone isn't.
No, all judges are meant to be indemnified by the Lord Chancellor. All of them. That's how they claim their public authority. That's why okay, on the public side, when they're acting on the public, enforcing statutes, they're indemnified by the Lord Chancellor. That's the Courts Act of 2003, I think. They've changed it to Courts and Tribunals Act of 2007 or 8. And on the other side, the private side, they have private bonds as well. So he's acting privately, doing the administrative work. He's not acting on an indemnification by the Lord Chancellor. He's acting on his private bond. You see, when he's doing administrative work. Also, he has to do the bond numbers, and they're never given to you. So that's how they can operate two-faced. Either as public or private, public or private. But right now, it's entirely private. There is no public anymore. Because everything is being sold off, everything is private. The courts are private. You go in, you see customers, hours of business. You're a customer. If you're a customer and you go to the court and you pay money to have a service, better make sure you get good service. Yeah. Make sure you get good service. No, the thing is, people have been scared and we believe this I call them idiots now, I've dealt with them. The ones where I live anyway, those are idiots, okay? Because I've dealt with them, so I know, I can even say their names. They always say district judges, this and that, but they're not. The trouble is this, we believe that somebody's smarter than we are. You know, they know more than we do, but they don't. You see, all you have to do is speak to them, and you realize these guys are full of them. They're full of crap. So just stand up for your rights, know who you are. No, you owe no one anything. Right? No one has any right to demand for you to give them money or for your time, because Chronos, Horus, time is the factor. We're here. Everyone's got their own time. But if I get to manipulate your time, that you're working for me, you see, that's what's happening now. whoever owns your time is your master, if you will. Yeah, who's your boss? I say I have no boss. My time is my own. I'll do whatever I want, please. And that's it. But it's a matter of time. Whoever controls your time is your boss. Because now you're going to stop doing what you want to do, you're going to do what they tell you. But if you owe money to someone, okay, the point is to channel people, funnel them into debt slavery. Once you're in debt, you cannot do anything because you spend every minute looking for money to pay off your debts. And these debts are perpetual. They're not going to end. They're going to carry on forever. If you pay one, then you spend another one. But as long as you're a debt slave, you cannot function normally. The point is to get rid of all the debts so you're free of debt, and you can breathe easier and live. The point is to breathe and live, to get rid of the debts. Once you do that, life gets very sweet. Right? Once you don't have these people hassling you all the time, and eventually they do leave you. Eventually they leave you alone. Yeah. Okay. So I think that's me for today. I'll be better organized next time. That's the announcement for anyone who wants to see it.